This is Susan Ning from Kingwood Medicine's Beijing office, and thanks to OECD for offering me the opportunity to present competition compliance efforts by Chinese authorities. I'm going to address three parts. One is the strengthening competition compliance from the legislative perspective. The second is from the law enforcement perspective. And last will be my summary and expectation. On 2nd January last year, China has announced its draft revision for Chinese antiminority law. There are several characteristic issues that need to be shared. One is that more attention has been paid to internet and tech giants. In analyzing the market dominance in internet industry, special attention has been paid to network effects, economies of scales, lock-in effects, mastery and handling data, and other factors. These factors are new, but very specifically mentioned in analyzing dominant position for internet industry, and this is really the first time to be included in the legislative at the law level. We also noticed that same conditions as a factor has been taken out for the necessary element for analyzing abusive behavior regarding differential treatment, meaning that the proof is not needed to be provided when analyzing whether differential treatment has been done by abusing party. Well, the same conditions may give leeways in the current legislation where such a difficulty to prove same condition may waive the abusive behavior operator from the implementation of the law. When trying to apply the exemptions under the AML, necessity analysis will be needed on top of the proof of technology improvement and the environmental protection, meaning that, again, it's more difficult for the operator to apply for the exemption application because necessity is not that easy to be proved when providing other elements to prove the technology improvement, efficiency, environmental protection, or in the economic downturn, those could be easier. And regarding the penalties for monopoly agreement that not even being implemented but reached among parties, the previous provision under the current legislation has been increased up to 50 million RMB, while the previous penalty could be only 500,000 RMB. And also for failure of filing, the penalty is also being increased up to 10% of the turnover in the preceding year. And that not only cover the general failure to file, but also cover the implementation of the concentration without approval after filing, the violation of the remedy decisions, and the violation of the decision of prohibiting the concentration. Not only the AML is being drafted for revision, but also we have seen a couple of new legislation in by various legislative bodies, including one that has been announced by the State Council this year in February, and that is the guidelines for anti-monopoly law in the field of a platform economy. in this guidelines, it is clearly stated it is still necessary to define a relevant market, and also substitution analysis is still the basic method. Of course, it has not only be covering the consumer side, the platform side, but also have various particular factors that needs to be analyzed in addition to traditional analysis methodology. We could see that data and algorithm shall be taken into consideration when analyzing the monopoly agreements, such as algorithm collusion and other behaviors. And also in hub and spoke comparison, we could see that the platform may play a role to organize and coordinate the hub and spoke arrangement. In abusive conduct, we could see that relevant rules are more specified, such as regarding the abusive behavior to differentially treat the other trading party, such as choosing one from two, or in the form of flow restrictions, or in the form of researching rights reduction or price subsidy. These factors are specially addressed by this guideline. We also notice that the frequently used VIE structures are specially addressed in these guidelines, where it is often used by companies, especially companies in the internet industry, to avoid regulation in China, especially in the last 20 years. And in this guideline, the control arrangement, especially VIE control arrangement, falls into the scope of a concentration of business operators, and just face the implementation of the law and regulations accordingly. In these guidelines, we see other points have been addressed, which is worthwhile to be sharing with, such as the data collection and privacy protection shall also be paid attention to and shall not be abusively used to differentiate trading parties. We also noticed that concentration of new startups or emerging platforms, even the revenue threshold is not met, but still because of the high level of concentration, or the small, even it's a small market, but it's emerging quickly, then it may be subject to the scrutiny of merger filing at the will of the enforcing agency. We also see that creative conditions has been imposed on merger cases as regulated by this guideline, such as special licensing, revision of the platform rules, or revision of the algorithm could be possible as conditions to be imposed under this guideline. In addition to the new legislation just mentioned above, we also see that in 2019, January, the revised guideline on automobile industry is also made effective. In this automobile industry guidelines, we see the intermediary operator are specially regulated, either to be included in the consideration or analysis of price maintenance or etc., or could be excluded. We also notice under this guidelines, after sale market could be a single brand market as well for abusive analysis. And of course, non-price vertical arrangement is also being subject to this guidelines. Last year in October, we also have the anti-monopoly guidelines in the field of API announced as a draft for comment. And this API market has been very active for law enforcement and could be very controversial for market definition. And in this draft, API market could be national and could be one single market as a start for analyzing the market. We also see the active law enforcement legislative efforts from local authorities, like the Shanghai Anti-Monopoly Compliance Guidelines for undertakings, and also Shanghai Competition Compliance Guidelines for undertakings. Those are made effectively on 2019, 2021 respectively. And also we see other local authorities are also active in making local legislation. We also see the strengthening of competition compliance from the law enforcement perspective, especially in the platform economy regarding the choosing one from a two practice. In some of the decisions made by relevant authorities, we have witnessed the analysis regarding characteristics of the platform economy, such as two-sided market, multi-sided market, substitution analysis, and etc. We also see that attention has been paid to flow restrictions, search rights reduction, algorithm analysis, and etc. It's interesting to notice that friend principle has been also mentioned and shall be complied with when the authorities try to analyze whether the business operators have charged unfairly high service fees or imposing unreasonable restrictions, and etc. Regarding the failure to file a merger transaction, we also see that by summer recently, it announced that the 22 failure to file cases has been investigated and closed, including those involving VIE structure. And we also know that more cases are still being investigated. And we noticed that the cases under investigation could have a long time span, as long as 8 years. To summarize, the recent action by Summer and local Summers present a clear policy signal of increasing antitrust enforcement in the future in China. And the new drafts, the new guidelines, and the other new legislation indicate that Chinese authorities are fully equipped to regulate Chinese economy development in the new era after COVID-19. That's my presentation. Thank you very much.